Hello, con law students. This is a lecture in which I will discuss the following topics. Each of them is covered in Chapter 2 of your textbook, but deserve greater emphasis or some updating. The first item we're going to go over in this lecture is going to have to do with the discussion about limited government, federalism and limited government. As your textbook explains, federalism is a bedrock constitutional principle that refers to the balance of power between the national or federal government and state or local governments. If you recall from my last lecture, we were a union of states before we were a nation of people. And that transition required careful balancing to accommodate the concerns expressed both in the Constitutional Convention and then in the ratification debates. The first three articles of the Constitution established the three branches of our government. Each of the three articles defines the powers of the branch that it establishes. Your textbook mentions only Article 1 and its list of powers of that branch in Article 1, Section 8. But each branch has its own list of powers. Article 2, Sections 2 and 3, I believe, lists the powers of the executive branch. And then Article 3 lists the powers of the judicial branch. Yeah, Article 3, Section 2. The act of listing powers is actually an act of limiting powers. The founding generation was concerned about limiting the reach of the national government. So they specifically listed or enumerated is the word, enumerated the powers that they gave it. This principle of limited government is further entrenched in the 10th Amendment, which was actually a concession to anti-federalists because the anti-federalists were concerned that the enumerated powers in the original Constitution did not do enough to limit the reach of the national government. And that was the point of the Bill of Rights, was to address and provide further limitations on the reach of the national government. But what I'm trying to emphasize here is something I feel like your book sort of overlooks. All three branches have enumerated powers, not just the legislative branch. The next topic that I wanted to go over is on dual sovereignty. Dual sovereignty means that, well, let me start with this. The textbook presents a case addressing the principle of federalism. It's called Gregory versus Ashcroft. And that particular case analyzes a provision of Missouri's state constitution where Missouri had imposed an age limit, I think it was 70 years old, on individuals who could be elected to serve in their state court system. So this is an act of Missouri's people. The people of Missouri chose to put an age limit on state judges. So in Missouri, judges are elected to their state court, and the Missouri people amended their constitution, their state constitution, to impose this age limitation. And so that case, Gregory versus Ashcroft, excerpts of it are in your textbook. But there's a mention in that Ashcroft decision of the concept of dual sovereignty. And so that's where I'm wanting to explain what that is so you aren't confused by it. Dual sovereignty means that the two governments, federal and state, operate on a level playing field. Notwithstanding the supremacy clause, the state governments are just as important and powerful as the federal government. Many of the founding generation might even say that the balance ought to tip in favor of state governments over federal governments, but that's for another class. But I want you to look at the supremacy clause here. I've got it printed on the screen there. It reads, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. and the judges in every state shall be bound thereby. So the supremacy clause is in there, and you read it and you think, okay, that means federal law is more important than state law. But I'd rather you not read it that way. The supremacy clause it's not there to elevate the federal government over the state government. It's there to elevate the Constitution or perhaps the Union. If a state government could contradict the U.S. Constitution with their own state laws, then what would be the point of the Constitution? For there to be this a lasting union with a lasting central government, states can't change it on their own. They have to act as a union to change the Constitution. So look at it this way. The Constitution is a choice by the people to give up certain powers to a central national government. And the Supremacy Clause is meant to uphold that choice. It is not meant to convert states into mere agents of the federal government. That's ridiculous. States have their own sovereignty, and they make their own laws that govern their own citizens in accordance with their own state constitutions. As long as those state laws don't conflict with the U.S., the federal Constitution, then the state laws are and will remain valid. To avoid an overreaching federal government, then, anytime a case involves this conflict of law between federal and state, you'll see the court apply a presumption, actually, that this state law is valid. So the presumption is that the state law is valid, that there is no conflict. So you have to overcome that presumption in order for the Supremacy Clause to even kick in. We'll learn more about dual sovereignty and that preemption later on in the semester, but I just kind of wanted to give you a little intro to that and explain what dual sovereignty was. I didn't want you to get confused when you saw that in the textbook. All right, next, I think it would be helpful for you to look at an additional aspect of federalism that is not really addressed in the textbook. And that is the power of federal courts to review state law. You'll learn a good bit about the federal court's power to review federal legislation and then to review actions by the president. You'll see that in later chapters and modules of our class. But there really isn't anything elsewhere in the textbook that talks very much about this issue of federalism, where you've got a federal court reviewing the actions of a state government. The Constitution does not explicitly say that federal courts can strike down state laws. And there was a great deal of debate in the Constitutional Convention and thereafter about whether that was within the scope of federal judicial power. The landmark case that illustrates this power is called Fletcher versus Peck. It's an old case decided in 1810. And rather than read that actual decision, what I've added to your reading assignment for this module is an article about Fletcher versus Peck. So I wanted you to know why am I adding on to your reading assignment? It's because this is an important federalism issue that isn't really addressed adequately. And you're just going to be reading an article about it, not the actual case. Next, I want to talk about the subject of checks and balances, something the textbook goes over, provides a really good example, but I want to add to it. So I have this nice graphic here that sort of illustrates what the part that the textbook mentions. It is the job of the legislative branch, as you know, to make the law. That's their business. Congress writes the laws. The executive branch enforces the laws. The president will have an opportunity to read all legislation and then sign it, which makes it officially the law. Or the president can veto the law if he disagrees with it, finds it unconstitutional. And as your textbook mentions, the Congress, if there's a 2/3 supermajority, they can override a veto. So that's the checking and balancing going through these two branches. The executive can veto legislation, Congress can override the president's veto. The judicial branch is part of this cycle of checks and balances as well, because once Congress makes the law, the president signs it, agrees to enforce it, the judicial branch can still strike it down. If the judicial branch has the opportunity to evaluate a law, meaning it's challenged, then the U.S. Supreme Court can strike it down, make it invalid, and have no effect. So the judicial branch kind of comes back in and plays its own role in this system. So all of that you see in the textbook. But the cycle of checks and balances is not complete until you consider this. What happens if Congress or the executive do not agree with the court's decision to strike down the legislation? Now, in that situation, you have two branches of government, the legislative and the executive branch, that both agree on the law's validity. And only the one branch is left. That one branch, the judicial branch, is at odds with the other two. So what happens then? And this is not a situation where the courts have greater power than the other two branches. They don't. They are all three co-equal branches of government. But it's also not an opportunity for either Congress or the executive to simply ignore the power of the judicial branch, or to flout it, to ignore it, and not obey it. Rather, the next move in this checks and balances system is up to us to amend the Constitution. So we, the people, we're part of this checks and balances system. So we have to, I'll give you an example, but let me remind you. The Constitution is intended to be the will of the people, an expression of the will of the people. And the Supreme Court is intended to be the chief interpreter of it. The court's decisions then become an expression or an elaboration of the people's will as reflected in the Constitution. And therefore, it should be respected as an effort to protect the people's will from abuses by Congress and the executive. But if the people's will changes, like if they don't want the Constitution to be interpreted the way the court has interpreted it, so if the people's will changes, there is a proper mechanism for changing the Constitution so that it reflects the changes in the people's will. I'm referring to amending the Constitution. And it may sound like a long shot. It does require a supermajority of the people to accomplish. It's a 3/4 vote by the people to amend the Constitution. But those obstacles protect the stability of our government. They prevent it from changing with the political whims of a slight majority of voters. You might have heard this referred to as the tyranny of the majority. We have this amending process that is difficult to prevent the document itself from changing too easily. It's just the Constitution is too serious of a document to be changed for transient causes, fleeting causes. One of the cases you're presented with in the textbook is referred to as U.S. Term Limits versus Thornton. And on page 34 in your textbook, you'll see a reference to what I'm just explaining, why we have this process for amending the Constitution and how it upholds the integrity of the Constitution. But I want to give you an example of where this final step in this check and balances system goes. And this is just in the context of lawmaking. You're probably familiar with the 1857 decision of the U.S. Supreme Court, Dred Scott versus Sandford, in which the Supreme Court was presented with a law that Congress had passed, the Missouri Compromise. The president had signed it, so two branches of government were in favor of it. And the court decided that in that decision that that law, the Missouri Compromise, was invalid, that it violated the Constitution and should be struck down. Also, in Dred Scott versus Sanford, the Supreme Court held that African Americans were not U.S. citizens, and therefore Mr. Scott had no standing to file a lawsuit asserting his freedom based on the Missouri Compromise. So that's the big decision of the U.S. Supreme Court that struck down Missouri Compromise and has this terrible decision about citizenship. 11 years later, the people amended the Constitution. The 14th Amendment to the Constitution was ratified by the people, and it overruled the amendment, overruled the U.S. Supreme Court. The 14th Amendment says that all people born or naturalized in the United States are citizens of the United States. So they're overruling the U.S. Supreme Court. There's your example of how the whole process has worked. So even though the court may seem like it has the final say on things, it doesn't. We do. We, the people, do. But to preserve the integrity of our constitutional system, we need to follow these legal avenues that provide for making changes, making the changes we want to see made. We should follow these legal avenues to accomplish that. There are several other cases that are going to be presented in the textbook that involve the separation of powers and checks and balances, and they'll help you see all of this in action. Okay, the next topic I wanted to go over with you is on federal legislation. In this course and then in your future legal careers, you're going to be using federal legislation a good bit. And so I want you to understand how it's organized. It's primarily contained in a volume of books called the U.S. Code, the United States Code, or you might hear it United States Code Annotated. Annotated just means that the printing of it contains commentary. So I thought you would benefit from seeing just how the U.S. Code is organized and what citations to the U.S. Code look like. So I'm going to pause here for a second. I'm going to share a different screen besides my PowerPoint. So bear with me for just a quick second. Okay, hopefully I am now sharing the Westlaw database here in the Jackson Library. And I'm going to go in Westlaw Campus Research. I'm going to select statutes and then U.S. Code annotated. Okay, now you should see here on your screen, I hope you're seeing this, that the U.S. Code or the U.S. Code annotated is divided up into 54 titles. Each numbered title is descriptive of the subject matter of the laws found within it. For example, let's look at title up here, Title 28 of the U.S. Code, which is appropriately labeled Judiciary and Judicial Procedure. So I'm clicking on that. Oh, there we go. Okay, so now we're in Title 28, and you'll see that, and this is true of all numbered titles, it's further divided into parts. So you have Part 1, Part 2, Part 3, 4, 5, 6, a lot of parts there, okay? In this example, there are 6 parts, and conveniently, each numbered part has a descriptive name that reveals its subject matter. For example, Part 5 of Title 28 pertains to procedure. Now, as you can see within each part, you're going to find numbered chapters, and these numbered chapters also have descriptive names, such as Chapter 114 here, Class Actions. Notice, though, real quick, the chapters are fairly sequential. They don't start over. The numbering doesn't start over with each new part, so it's continuous there. But then, okay, so back to Chapter 114 for on class actions. I'm going to click on that chapter here. And you see that chapter 114 is then divided into sections. And I want you to look at this little squiggly symbol here. That's the section symbol. That's what is used to refer to sections in legal writing, not just in the code, but in any other reference to section. You'll see those little symbols there. It's mostly in referring to statutes. You'll see that. This section then is the section is numbered, but then you'll also see a little description of the content there. All right. I'm going to click on the first one, section 1711 on definitions. All right, now you'll see how within the sections, you'll see little numbered clauses. Sometimes it'll be 1, 2, 3, but then sometimes it could be 1A, 1B, 1C, and so on and so forth. It breaks it down into very much like an outline format, and they can go on, depending on how detailed and complex the legislation is. But I just wanted you we'll actually take some time to go into the Jackson Library's database for Westlaw database, and you can kind of look around through the U.S. Code and sort of familiarize yourself with how it's organized. I just want you to be prepared for that. You'll need to know that for your future legal careers, but you're also going to see this in this course as well. All right. So now I'm going to go back to sharing my PowerPoint. Hopefully, you're seeing what I want you to see, which is our next topic these are updates. My last two slides here are just updating the information that your textbook provides. The textbook was printed in 2013. A lot has happened in the world of constitutional law over those 12 years. So what I'm going to do in this module and then perhaps in future modules as needed, I'm going to give you the more updated the developments that have occurred since the publication of your textbook. And so the first one that I want you to know about is on impeachments. Your textbook on page 37 reads that there have been only 2 impeachments of a president, but as of today, there have been 4. So just making sure you're up to date. It's happened 4 times, not 2. The first time was impeachment of President Andrew Johnson. Oh, I'm sorry. And we're talking about presidential impeachments. There are other federal officials that can be impeached. For example, judges on the federal courts can be impeached, and there have been many impeachments of federal judges. So it's not just presidents, but the correction I need to make has to do with presidents. So the textbook tells you Andrew Johnson, there was an impeachment of him in 1868. Then the second one, Bill Clinton in 1998. Okay, that's where your textbook publication then intervenes in 2013. But then in 2019, the House of Representatives impeached Donald Trump, accusing him of corruption. And then again in 2021, the House of Representatives impeached Trump again, this time accusing him of inciting the January 6th insurrection. It is still accurate, however, that no president has ever been removed from office as a consequence of his impeachment. So on each of the 4 occasions, the Senate never garnered enough votes to actually remove the president from office. So I'm going to take a second and just elaborate a bit on this process. As the textbook explains, it's up to the House of Representatives to issue articles of impeachment. They may do so whenever a majority of the House members believe the president is guilty of high crimes or misdemeanors. The Constitution doesn't define what is meant by that phrase, high crimes and misdemeanors, but in each of the instances of an impeachment, it has been something very, very significant, some form of serious corruption. The Constitution requires a simple majority of the House to issue articles of impeachment. So that means half plus 1. So 50% of the House plus 1 more. There are 435 seats For voting members in the House of Representatives, a simple majority of 435 is 218. So it takes 218 members of the House to issue articles of impeachment. And you can see in your textbook that articles of impeachment will read a little bit like a criminal indictment. It's just a description of what the person being impeached has been accused of. So it's like a complaint or an indictment, sort of. And there's some examples that are provided, good examples in your textbook of that, so you can see. Once those articles of impeachment are issued, the matter then is going to go to the Senate. The Senate is where an impeachment trial will be held. Unlike criminal trials where the rules of procedure and evidence are preordained, the Senate has the discretion to set the rules for how the trial is going to go. They have a lot of discretion. So they have their own rules to guide the process. They're relatively complex, leave a good bit of room for variation, but they're going to establish the depth of the investigation, how long they're going to hold the trial, the intensity of the investigation, whether witnesses will be called to testify, or maybe it's just going to be subpoenas, documents. So they have the discretion to kind of decide how hard they're going to look at the evidence, how much time they're going to spend on the matter. And then the Constitution requires in order to remove a president, you must have a 2/3 super majority to remove the president, which is 67. So you have 67 members of the Senate are required to vote in favor of removing a president following an impeachment trial. And that's never happened. Okay, so that's end of my update about impeachment, and we'll look at our last update. The last one has to do with executive immunity. On page 40 of the textbook, it reads that whether a president could be prosecuted in a court of law is an unanswered question, right? Well, that's no longer true. The question has been answered. So let me go back just a second. The section in your textbook on executive immunity presents a case. I believe it's Clinton versus Jones. I don't have it in front of me, but I'm pretty sure that's the one. That's still valid law. So that deals with the president's liability in civil actions. So whether executive immunity would apply in the case of civil actions, and it doesn't. You'll see that explained. But this part where it says whether a president could be prosecuted in a court of law, so this is a criminal action. The textbook says that question is unanswered, but it was answered pretty recently. It was answered in 2024 in the case of Trump versus United States. And that's not in your textbook. This is a rather long and complex decision. I'm not asking that you read all of it. I am going to include some excerpts from the majority opinion, and then there were three dissenting justices, and I've chosen some excerpts from the primary dissenting opinion. I wanted you to see both sides. So keep an open mind. I know that Donald Trump is kind of a polarizing figure in our nation, but I'm just asking you to set aside your feelings towards him and recognize that this decision of the U.S. Supreme Court, this is a precedent that will apply going forward into the future to all presidents from any political party. So, however you may feel about Mr. Trump, set that aside, read these excerpts as the legal reasons why we might or might not want one branch of government to criminally prosecute the member of a co-equal branch of government for actions he or she took while in office. So that's why I want you to try to consider that. Take your political beliefs out of it and just look at the legal reasoning that is explained by the majority and by the dissent. And you have your own opinions, who has it right and who has it wrong. But I've got the final holding. You can read there on your screen. the U.S. Supreme Court, the majority, so 6 of the 9 justices held that executive immunity does apply in criminal actions based upon official acts. And it kind of talks about what are official acts. And then the court held that executive immunity is presumed, so it can be rebutted, but it's presumed to apply in criminal actions based upon conduct within the outer perimeter of official powers. Okay, so that's the bottom line holding as I understand it, and I want you to read those excerpts and consider it for yourself. Okay, so that's the end of my lecture for Module 2. Go on and do your reading assignment if you haven't already. And if you have any questions about what you're reading, something you don't understand, please call my office or email me, come by and visit me. I'll be happy to explain things further. Great. Have a great rest of your week.